Everybody, welcome to part two of Police and the Law, Legal Issues. I was talking about probable cause, which I'm going to move into in just a second, but let me just finish up with these different parts. So below probable cause, below a moderate amount of legally sufficient evidence, standards of proof, is what's known as reasonable suspicion. This is the amount of evidence that the police need in order to conduct a stop, question, and possible frisk. And it comes from the Terry v. Ohio case. And if you remember earlier from part one, I had mentioned the Fourth Amendment, and I said unreasonable searches and seizures. Reasonable suspicion is based off of that standard. What is reasonable, what is unreasonable. In New York State, we have what's called common law right of inquiry, founded suspicion. It's a step lower than reasonable suspicion. We also have requests for information. Those vary state by state. New York State bases its standards of proof at this level off of a New York State Court of Appeals case, People v. DeBoer. If you'd like to take a look at that, you can get a good sense of what the police can do in New York State as opposed to the rest of the country. Okay, so probable cause, reasonable suspicion. I call these the king and the queen of all things Fourth Amendment, all things policing. These are absolutely must know inside and out in terms of policing the law. Probable cause. So we're going to define our operational definition of probable cause as evidence that may lead a reasonable person to believe that a crime has been committed and a certain person committed it. It's necessary amount of evidence for an arrest. It's a necessary amount of evidence that the police need to do a search to get a warrant. It must be established before an arrest is made, before a warrant is issued. And the government can search, which is different than a frisk or different than a stop. So I want to just differentiate right there. Probable cause, facts and circumstances that would lead a reasonable person to believe that a crime has been committed and a certain person committed it. It's basically probably. It's probably true. More than 50% chance it's true. If somebody says to the police, "Hey, officer, that guy right there just pulled the gun on me and told me to give me his wallet," it's probably true. Could it be false? Yeah, but it's probably true. The police are interested in probable cause at this stage of the criminal justice process. It's up for the other parts of the criminal justice system, the prosecutor, the courts, to determine proof beyond a reasonable doubt. Right? The police only need probable. Below probable is what's known as reasonable suspicion, less than probable cause. Right? This is the amount of evidence necessary for a police officer to believe that a crime is happening, was happening, or did happen. Okay? Past, present, or future. It's a necessary legal standard for the police to conduct a stop, question, and possible frisk. If the police believe, reasonably suspect, doesn't need to be true, it just needs to be reasonable. If the police reasonably believe that you are engaged or a person is engaged in a crime, they can forcibly stop you, forcibly, even at gunpoint necessarily, if it's a violent crime involving a weapon, absolutely. So they could forcibly stop you, they can question you, and they could even frisk you for a weapon. All right. This is the necessary standard. It's less than probable cause, and probable cause can be developed off of reasonable suspicion, and it frequently is. And often reasonable suspicion will lead to nothing. And this is one of the big controversies of reasonable suspicion, especially stop, question, and frisk, because it often leads to nothing. And so many people would say, well, is it reasonable? And courts look at those things, and they have to decide them on a case-by-case basis, based off the facts and circumstances that the officer had at that time. Was it reasonable or unreasonable? Based on their actions, were they reasonable or unreasonable? Okay, so key here: probable cause is the amount of evidence for an arrest. Probable cause is the amount of evidence for a search. Probable cause is the amount of evidence necessary for a arrest, search, or search. We'll keep it at that, or a warrant. Reasonable suspicion is the amount of evidence necessary to conduct a stop, question, and frisk, a short-term investigation. Okay, so just going back to the Fourth Amendment again really quick. This is a full reading of the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. All right, I want to underline persons, houses, papers, and effects. This was written in the 18th century, and these have different meanings back then than how things apply today, but they still do apply today. Some people would say, well, it doesn't say anything about computers or cell phones, but that's Fourth Amendment certainly applies today to those things. So vehicles, they absolutely apply. So it's still applicable even though the technology changes. This applies to warrants, search and arrest warrants. It applies to searches of property in general. And this requires that the government must obtain a warrant before arresting or searching someone, except in many, many circumstances, which courts, through case law, have made known. Okay, and a way to remember these exceptions, these are general exceptions, is through this acronym, SPACESHIP. SPACESHIP, I'm using an acronym. An acronym is just the first letter of each word in order to form a new word. It's a mnemonic device that'll help you remember things. So exceptions to the Fourth Amendment, you have search incidental to lawful arrest, plain view, auto, consent, emergency, stop, question, frisk, hot pursuit, inventory, and then period, meaning there's nothing else. Okay, so we'll go through these one at a time. The first exception to the Fourth Amendment, the requirement to get a warrant, is what's called the search incident to lawful arrest. What makes an arrest lawful is that the police have probable cause. It doesn't matter how petty or how serious it is. It could be murder, it could be petty larceny. If the police have probable cause, it's a lawful arrest. Okay, we could talk about discretion at a different time, but it's a lawful arrest. So the police, under the law, under the Constitution, as per case law, Schimmel v. California from 1969, the police can do a search incident to lawful arrest, head to toe, and reachable, grabbable area. They're looking for what are known as the three E's: anything that could aid in your escape, anything that could endanger you or them, or any evidence that could be used against you. All right, so the three E's. Okay, search incidental to lawful arrest. The police can do a head-to-toe search. The second exception is plain view. You leave property out, or the police are called to your home because of domestic violence, or somebody's home because of domestic violence, and they're not there searching for anything. They're not there searching for drugs necessarily or weapons, but they go into the home because there's a big dispute, and on the table right in front of them, in plain view, out in the open, is all kinds of drug paraphernalia or something, right? Unconcealed and inadvertently seen, abandoned property, open fields, that sort of thing. Plain view exception. The next one is what's called the auto exception. This comes from the Carroll v. United States case from 1925, also known as the Carroll Doctrine. Courts have determined that because of the inherent mobility of vehicles, that there are fewer Fourth Amendment protections in vehicles as opposed to homes and people. Right. So when you get arrested or somebody is arrested, search incidental lawful arrest in their vehicle, depending on what it's for, different rules apply. So reachable, grabbable is anything in the passenger compartment, the center console, the glove compartment, the back seat. All right, anything that's under the control of the operator of the vehicle. Now, if it has to do with drugs or weapons, then the police can do a bumper to bumper search on a vehicle. Drugs or guns, that's bumper to bumper automatically. And when you're in a stolen vehicle, everything's out the window. It's sort of like guns and drugs, stolen vehicle, then pretty much everybody's getting arrested. So stay away from stolen vehicles, folks. Anyway, the bottom line here is the auto exception allows the police to conduct a more thorough search and a wider search on search incidental to lawful arrest than they would just a regular person. Okay. So that's the auto exception. You can look that up and you'll see it in constitutional law as you study that as well. The next one is consent, right? Consent search it has to be given by somebody who has authority over that property or person. Like when you go through the subway and the police ask to search your bag, you're consenting to that, and you might not feel that way, but it actually is a consent search. They can't arrest you the police can't arrest you for refusing to consent, but they could eject you from the subway because that's state-owned property, state and city-owned property, but they can't say, no, we have to search your bag or you're under arrest. You have to consent to that, and that's a consent. Police show up at your home. Hey, can we search your kitchen for drugs? And you say, yes, you can. It's my kitchen, and I live here by myself. You could search. Not that you would like me to do that, but consent must be freely given, free of pressure, free of duress, and it has to be given by somebody who has authority over that property. So, like your own person, you have authority over your own person. You have authority over like your own personal property. And then there's like emergency exception, or sometimes what they call exigent circumstances, in order to prevent escape, prevent harm to officers, prevent destruction of evidence, render immediate aid. And then, so you have this really high-profile incident that just occurred. Maybe it was a kidnapping, and the police. It just happened 5 minutes ago. The police capture the bad guy, and they save the child. God forbid, right? The child is saved. It's possible that person, I mean, think about this. Is it reasonable that that person, the kidnapper, might have kidnapped another kid, right? And so maybe you have to question that person without giving them Miranda, because you're thinking about is somebody else's life in jeopardy, So that's prevent escape, prevent harm to others, right? Render immediate aid, emergency, exigent circumstances, exigent circumstances. That's what those are considered. Also, then you have this idea of stop, question, and frisk, which is not a search, but it's a frisk. A frisk is the outermost garment. A search is inside pockets. It comes from the Terry v. Ohio case, landmark case, a huge case, and it's one of your assigned readings for this particular lesson. You have to go in there and read this. If you want to understand stop, question, and frisk, what that means, what the police can do, what they can't do, that's the case to read and to understand. It allows the police to temporarily detain somebody for the purposes of an investigation because they reasonably suspect that a person was involved in a crime, past, present, or future. Not probably, because if it was probable, they'd be under arrest, and then they would be searched. Frisked is under stop, question, and frisk. All right. Hot pursuit, that's when you're chasing somebody, like for a crime. Then they run into a constitutionally protected area like a home or vehicle. The police can go there and follow them. If they're in hot pursuit, they have probable cause of a crime. And then the inventory is for safekeeping. Like when the police place somebody under arrest, they have to take all of their property. And that property, the police are required to safeguard it. They have to protect life and property. So, if they're going through somebody's bags who's been arrested, they're not searching for weapons or necessarily, but they have to inventory everything in that bag. So, if they find a gun and it's there illegally, then that could be used against the person because it was an inventory search. It wasn't a searching for weapons or drugs or contraband. All right, so custodial interrogations, and this is leading us to the last part of the lesson. People find this really interesting. They think that every time somebody gets arrested, they have to be Mirandized, like from TV and movies. The bottom line here is this, is that somebody is in custody and they're being interrogated. That's when custodial interrogation applies. Custody means you're under arrest. You're not free to leave, and you're being asked, you're being called for a crime based off of probable cause, the initial taking into custody of somebody. A Terry stop, a stop, question, and frisk, is a temporarily detaining for the purposes of an investigation. Miranda doesn't apply under Terry. All right. In order for Miranda to apply, it must be under arrest. You must be under arrest. Right. You must be under arrest. All right. So when you're in custody, you're not free to leave. You're under arrest. Then the police, and you're being interrogated, not questioned, but you're being interrogated. Interrogation means you're being asked about the specific crime, all right, that you might be involved in. Not where do you live, what's your name, what's your home address, you want to make any phone calls. That's not interrogation. Custody plus interrogation equals Miranda. That's when you have to be given Miranda, right? That's when you have to be given Miranda. And that's what people get a false impression of that from TV and movies. It comes from the Miranda v. Arizona case, and the case that preceded that was Escobedo v. Illinois. Certain exceptions like spontaneous utterances, basic questions, things like that. Okay, moving along to the last part, eyewitness identification. You see that this is what they do in lineups, right? It comes from the US v. Wade case. I encourage you to take a look at that, right? You have to have sort of matching characteristics, demographics, gender, things like that, race. And then the last part is show-ups. Show-ups is when they bring the police have reasonable suspicion that somebody committed a crime. They have a victim, and then they have a potential perpetrator, all right? Victim says, oh, that person just robbed me, or I was just robbed, and they give a description. So the police stop somebody who matches that description, approximate time, approximate location, and then what they do is they bring the victim, very important, they bring the victim to identify the perpetrator or the potential perpetrator. They bring the victim, all right? This is called a show-up. This is called a show-up. Courts want the victim to be brought to the perpetrator because anything else is unnecessarily suggestive. Excuse me. Like the cops handcuff this guy and they bring him in the back of the car to this person. It looks like the person's guilty, so that's suggestive. The only exception to this is when they don't bring. Well, generally, the only exception to this generally is when they don't bring the victim to the perpetrator is if the victim has to go to the hospital or the victim's likely to die. Some kind of really horrible crime. Right? Called a show up, on the scene show up, okay? And they bring us for identification purposes. This takes reasonable suspicion and turns it into probable cause. Somebody gives a description, gender, race, age, time, location of a crime. Police stop somebody. victim, goes to the perpetrator, and they say that's the guy,